All right, what's up, YouTube? We back doing a little more studying, some paperwork I gotta get filed. All right, basis for jurisdiction. This is your pleading. This is you pleading. One matter that can arise with respect to the basis for jurisdiction is the question of whether facts establishing a basis for jurisdiction must be alleged in the plaintiff's pleading. Some states do not require that a plaintiff plead facts justifying the use of certain forms of substituted or constructive services. In such states, the failure to allege the condition justifying long-arm jurisdiction may itself be a jurisdictional defect warranting dismissal and quashing of services. If the allegations are sufficient, however, the effect may be placed on the defendant the burden of abducting evidence to disprove allegations. So you got to look at all these case notes there in the bottom 8. Gives you some right here. Statement to the effect that conditions justifying long-arm jurisdiction must be alleged in the complaint occasionally may have been made by federal courts. 9. Now it says you don't have to do all that fun stuff. Keep on reading. Now it seems quite clear, however, that no such requirement is imposed by federal rules of civil procedure. You can look at 10 down here. See additional notes for credit union administration fraud. Federal courts bound that follow state rules that would require such pleading. The provision of federal rules of civil procedure, Rule 8, subsection or paragraph A1, requiring the complaint to include statement on the grounds upon the court's jurisdiction depends refers only to subject matter jurisdiction. Other decisions have expressly rejected the idea that the facts supporting personal jurisdiction must be pleaded. Paragraph 12, down here, 12 right here. These are cases that you can look up. You have to read these last of personal jurisdiction is regarded as an affirmative defense, and the court did not cite Tipton versus Manafort, Note 7, Super Supreme. So all these court rulings talking about lack of jurisdiction. Subject matter jurisdiction. The absence of such allegations in the pleadings does not support a collateral lack on a default ruling or default judgment. So if you have a default ruling or default judgment like in your court case, then this right here pretty much states the absence of such allegations in the pleadings does not support a collateral attack on a default judgment. Burden of proof. When the basis of jurisdiction is challenged in the onset of the lawsuit, which you're in the lawsuit anyway because you're in court, general effect upon himself plaintiff the burden of proof or facts supporting jurisdiction. However, with respect to questions relating to the constitutional basis for jurisdiction. Burger King Corporation versus Ryder. Declare that once the plaintiff establishes that the defendant purposely established minimum contacts with the state, the burden will be on the defendant to show that exercise of jurisdiction would not be reasonable in the light of the fairness considerations that make up international shows. Fair play and substantial justice. Requirement. A few states put the burden of proof on the defendant with respect to statutory jurisdiction requirements as well. In most states, however, the basic burden is on the plaintiff. So the plaintiff, that's why I'm saying the burden of proof is on the state, because they're the plaintiff, you're the defendant, you're defending yourself. The exact procedure of resolving jurisdiction issues is subject to considerable variation. There is no statute prescribing the procedure for resolving the issue in federal courts, and so the mode of its determination is left to the trial court. If the issue can be resolved by documentary proof and affidavits, a hearing may be unnecessary. That's why I said I got all them tickets out. You get them thrown out because, see, resolved by documentary proof. All them paperwork that I showed you that were stamped and notarized by the court clerk, that's me providing documents and proof made by rulings of a higher court, which lower courts are bound to uphold all higher court rulings. So a higher court ruling would be a federal rule Supreme Court. Those are higher courts, and all the little circuit courts you go to for tickets, those are lower courts. Those aren't even courts anyway. See, some courts are trying to establish by respondents of the evidence at the hearing fact providing a valid basis for jurisdiction. See? So you have to write them asking how they have jurisdiction. If they fail to do so, failure to do so will result in dismissal. So you write them, say, hey, I have all these rules. You got so many days to respond, because it's like the ticket. If you don't respond in 14 days to dispute it or challenge it, then it's silence is acceptance in the eyes of the law. So, prima facie, look up that. Requiring only a prima facie showing to avoid dismissal is not limited to such cases. However, this approach is somewhat anomalous if the plaintiff fails to prove at trial the basis for jurisdiction. The action theoretically should be dismissed for want of jurisdiction, even though the merits of the claim have been litigated. Even if the action is then dismissed, the defendant will have lost much of the very right to be litigated in the case in that form, although many cases can be cited in which the court has purposely to reserve final decision in a personal jurisdiction question. Yeah. Can't talk, I need something to drink. But see, you have to rebuke these. You have to send them a letter in the mail once you get a ticket. And I mean, this is showing you resolving jurisdictional issues that are also substantive issues. All right, let's look at some other ones real quick. Burden of proof is on 8. We just seen that one. Ruling denying motion to dismiss the quash. Ruling granting motion to quash services. Let's look at that one, 22. Challenges to... Ooh, here we go. I'm skipped about 3 pages anyways. This is a good one. All right. And defendant participated in action. Objections to personal jurisdiction either will have been waived or there have been made a ruling rendered by the trial court. If the court ruled against the defendant, the only resource for the defendant is to seek appellate review after having litigated the question of jurisdiction. The defendant cannot avoid the consequences of an adverse ruling except by appealing the ruling. Other devices for directly or collaterally attacking the result judgment are no longer available. So say if you don't do something, it's no longer available. If the defendant does not participate in the action, however, he may be able to make his objections to the basis of process elements of jurisdiction after judgment. And so you can look up all these cases and tell you what the ruling was, what the motions were, what the final outcome, the summary, and then actual ruling. And that's what you have to read all these cases and find things in these cases that apply to you. See? All right, where's it at? Blah, 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 blah. See, most might change the venue to jurisdiction and venue, challenging jurisdiction and venue. Striking a motion, challenging jurisdiction and venue. Direct attack on a fault judgment. Ooh, that's what I need. Alright, I won't sit here and bore you all forever. Hit the like button, smash that subscribe button, and we'll learn how to do all this stuff together. Because if this gets good enough, I'll be taking my happy ass to law school. And, yeah. We'll take care of y'all and make sure everybody gets right by these books. And we'll make sure they stick to their books. So, this is what I tell you. You need to learn what these books say. You need to start learning about how the system works. So, because you will be led in the dark by a bunch of dummies. Peace out, y'all. Have a good one. Happy 4th. Hit that like button, smash that subscribe button.